welcome. I feel welcome. I can tell you that I go to a lot of different courtrooms. I go to a lot of, thank you, a lot of different venues, a lot of different administrative tribunals, Jeff City, Springfield, Branson, all over the place. I even go to courthouses where there's a sign on the water fountain that says, "Don't spit in the water fountain." But this is a real pleasure to come to, and I think that you all are in very good hands here. I want you, and Daniel and I want you to understand what we're talking about before we leave. In other words, we want you to understand the presentations. I was watching TV last month, and I saw this book being advertised on one of my favorite channels, and it's written by Alan Alda, who used to be on MASH. He is still alive, he's an old guy, obviously, but he now writes a lot of books, and he's very interested in communication, and he's written a new book called "If I Understand You, Would I Have This Look on My Face?" Now, normally, whenever I'm in a courtroom, or if I'm in a hearing room, or if I'm in a conference room, and I'm talking to a client, or I'm just talking to a couple of lawyers and a judge, or I'm just talking to a few people, I can look on their face and I can see whether or not they get it. I want you to get it. Now, in this room, I can't really look at your face because there's really too many of you and I can't sort you out. So if you have a question, raise your hand and say, "Could you repeat that?" Or "Could you say that a different way?" Or even something as basic as that, because we really want you to understand what's going on here. I'm going to be talking about the latest legislation that was passed by the Missouri legislature concerning workers' compensation. That's called Senate Bill 66, and that's in the electronic materials that Connell has sent you. Daniel is going to be talking about amendments to the employment law, and most specifically the Missouri Human Rights Act that's part of Senate Bill 43. All of this legislation takes effect on August 28, 2017. That is our annual anniversary date for the effective date of legislation, unless there's what's called an emergency clause. And there's no emergency clause with any of this year. This is the way that it works. Sometimes there is legislation that is stayed until the next general election, because petitions have been circulated and signed, and they're sent to the Secretary of State, in which a sufficient number of petitioners in Missouri congressional districts can hold off the effective date of legislation until we have a statewide vote on it. I don't expect, especially my bill, Senate Bill 66, to be stayed off. I think that's good to go. I really don't think that Daniel's Bill 43 is going to be stayed either. The right to work legislation that was passed and signed, don't know yet. There have been petitions circulated. They've been presented to the Secretary of State. There's already been litigation. So if you're interested in right to work, that is very much a work in progress, no pun intended. But for right now, I'm treating with my clients and with audiences like my bill's going to go into effect. I don't think there's going to be any change with that. A few abbreviations I need to talk about. Whenever you see an abbreviation ER, that means employer. IR means insurer. TPA means pretty much what you understand it to be. Every once in a while, I'll show a citation that says what I call RISMO Sup 2017. That refers to the bill that was passed this year, and that is in the bill that is in your materials. When space permits, I go ahead and quote the bill. I don't like the word transparent, but I do like to show you what I'm talking about. So if I can get it on a slide, and if it's worthwhile, I'm going to quote it. Whenever you look at those bills, as I suspect that you will, there's a trick to reading those. If it's in bold type, that's something new. If it's in brackets, it's gone, deleted, or it's being renumbered. In September of this year, I suspect that you can go on the reviser's website for the reviser of statutes for the state of Missouri and pull the whole law if you want to. I normally keep a working notebook that's about this thick, where I have the entire workers' compensation law in it in printed form, so if I get tired of looking at it on my screen, I can just read it in paper. So it'll be there. But for right now, Senate Bill 66 is the only resource that you can really look at in which you can see what's going to go into effect. And lastly, and importantly, I try to get you introduced to concepts and give suggestions. This is not final legal advice. And more to the point, Daniel and I understand that we live in an age of LegalZoom. So you are probably working with an employment manual, some employment policies that you've either pulled off the Zoom or you've pulled off from competitors or colleagues or God knows where. That's okay, but we'll talk about that because, frankly, it comes up. Okay, that's supposed to be a drum roll for the first subject, and, well, it sounded better whenever I was making this. But first of all, we're going to talk about a subject near and dear to every HR specialist's heart. We're going to talk about drugs. Because drugs is the main topic, one of the two main topics within Senate Bill 66. Drugs is one, drug testing is one, and workers' compensation retaliation is another. There are aids for you now in drug testing. There are traps for you in workers' compensation retaliation. But first of all, let's go to drug testing. Why is drug testing important in workers' compensation? Primarily, two reasons. If there is an alcohol or illegal drug use that violates an employer's policy, there are situations in which there can be a 50% reduction, what we call a 50% penalty in benefits awarded for temporary total, temporary partial, permanent total, not medical, or death benefits. If there is a violation of an alcohol or illegal drug policy, which is the proximate cause, what lawyers and judges call the proximate cause of the injury or death, then there's a complete forfeiture of benefits, meaning the employee or the dependents get zero. Okay, so that's why it's primarily important. You should have alcohol and drug policies anyway. Do not have alcohol and drug policies just because of lawyers like me betting on the lamb or come that you're going to beat a claim someday, because that's normally not how it works. So you need to take an integrated view of your alcohol and drug testing policies. This is part of it. It can be a very important component of it, because if you ever have a $250,000, $500,000 claim someday, and you might, you want to be able to figure out how to work out benefits, how to settle the claim, what you can look for whenever you try the case. So it's an extremely important tool, but it should not be the only tool you have. What's the new procedure? There are 4 new elements for testing procedure that you must comply with in order to even consider a 50% penalty or a forfeiture. Actually, more than likely, the 50% penalty. But this is it right here. The initial testing was administered within 24 hours of the accident or injury. That's not 24 hours within notice of the accident or injury. That's 24 hours within the time of the accident or injury. 2, notice was given to the employee of the test results within 14 calendar days of the insurer or group self-insurer receiving actual notice of the confirmatory test results. Third, the employee was given an opportunity to perform a second test upon the original sample. How often do you do that these days? Got to do it. Fourth, the initial or subsequent testing that forms the basis of the presumption of presence of an illegal substance was confirmed by mass spectrometry using generally accepted medical or forensic testing procedures. Sounds pretty simple. It's certainly not as complicated as what we see for DOT testing for truck drivers. You look through those regulations, you'll go blind. So this seems pretty simple. But there's a trap here for you. And the trap here is that we strictly construe the workers' compensation law, and we have done that since 2005 because there were legislators sympathetic to your interests who said we're strictly going to construe the law, and they were thinking that that was going to make it a pro-employer, anti-employee law. Well, there's normally two sides to the sword, and the other side to the sword is that you shall comply with all of these before your test is admissible in order to get to the 50% reduction. Whenever I said forfeiture, I was overspeaking, but this only applies to the 50% reduction. So if you don't give notice within 14 calendar days, yes, ma'am. Great question. I'm not sure. And I'll get into that, but
and Pat,
I think the answer is no.
Pat, I'm sorry
Yes.
to interrupt. Would you mind repeating the question so that everybody can hear?
Sure.
Thank you.
Do these elements apply to the forfeiture? I'm not for sure, but if I were to make an educated estimate, the answer is no. So this is what applies at least for the reduction. Why do we have a specific procedure to qualify for the 50% reduction? It stems from the fact that we had a lousy law written in 1990 that nobody understood. Normally, you have to have a connection between the violation of the policy and what happens. It's the old story where your welder goes to the ZZ Top concert on Saturday night and smokes a few joints, and then he goes back to work the next week and he gets hurt on Thursday. You put him in for the drug test and he tests positive, but there was no evidence of impairment. Okay? In that situation, can you take the 50% penalty? Well, nobody has really known for 27 years. So the elements were set forth this year in order to give employers the opportunity to prove the 50% reduction. We have always required that the phrase was sustained in conjunction with the use of alcohol or illegal drugs means that that triggers the 50% reduction. But we've never had any case law in 27 years that told us what that meant. Lawyers and judges know what proximate cause means. So figuring out proximate cause for people like us isn't that hard to figure out when you're talking about the forfeiture. But what in the world does that phrase mean? Was sustained in conjunction with the use of alcohol or illegal drugs. Nobody knew. And there had not been any case law, there had not been any cases litigated before division judges where parties had resolutions where we had guidance so that people like me can tell you whether or not that reduction is going to be successful or not. So rather than go through more years of uncertainty, the legislature has said, get these 4 elements done, and you've got a presumption of a violation of your rule, which qualifies as a 50% reduction. But remember, if the employee can show that this testing procedure was ineffective, or can show a different result on a second test, you may not still get the reduction. But that's basically what it means. So rather than us try to figure out through cases, was sustained in conjunction with the use, the legislature said, phooey. We're just going to set forth a procedure. If you follow the procedure, that's going to work. And if you don't follow the procedure, you don't get the 50% reduction. Strict construction. That's what that means. Okay, let's talk about forfeiture. Let's come back to this lady's question about forfeiture. What if you have a case where a driver is driving down the road, an employee is driving down the road, company vehicle on the job, takes out 300 foot of fence on highway right-of-way, crashes into a pole, killed, and you find a pint of Jack Daniels in the seat next to him that's empty. The highway patrol trooper says that he could smell intoxicants on the dead employee's body. You have all sorts of tires, skid marks, row marks that as a totality show death by intoxicated driving. But let's say that there's no drug test, or the drug test comes back inconclusive because of other reasons, because of other medical reasons. Can you show a forfeiture in this situation where, for example, $600 of lifetime death benefits for the widow are going to be forfeited? I would think that with the way that we have the statute worded now, that forfeiture is worth a try, at least to present to the division, because the statute, the elements that I showed you before, expressly do not apply to the 50% reduction. So if you have aggravated cases, like the hypothetical I just gave you, I think you're still in the ballpark to play ball. And I think that is still a possibility. So there are going to be situations in which, just based on a factual matter, regardless of test results, that you may have a good case to show intoxication or drugged condition. But you won't be able to get the 50% penalty due to some legitimate reason. But even though it's a legitimate reason that you can't get the testing, doesn't mean that you can still get the reduction, but you might be able to get the forfeiture. There are going to be situations in which your employee refuses the drug test or the alcohol test. This comes up. And there's going to be situations, especially with driving employees, where they're going to have Fifth Amendment concerns or some other kind of concern where they're genuinely not going to want to take the test. Well, for purposes of criminal law, they can refuse. But for purposes of you as the employer, what happens when they refuse? Now, hopefully, you have a policy that you have thought past just copying off what you got from the Zoom that tells you what you're going to do with them. And I'll get to the 6 W's here in a minute. But what happens for purposes of the workers' compensation benefits? Here are the elements. When the employee refuses to test for alcohol or illegal drugs at the time you request, then benefits are forfeited, meaning zero, if the employer had sufficient cause to suspect the use of alcohol or illegal drugs, or the employee's policy clearly authorizes post-injury testing. Those red words are very important. Don't mix them up. I put them there in that reason because it follows the statute. And you can't mix the elements up. If you do, you're going to get confused on what you can and cannot do. So, if they refuse based on your request, not on a medical request, on your request, Why is it important that it's your request? Because when you request, it's not part of medical treatment. When someone is picked up and taken to the hospital, for example, I'm going to show an example here. When someone's picked up for a suspicion of intoxicated or drugged driving and they're taken to the hospital, when the nurse, as at the instruction of the physician, takes the blood test, that's medical treatment. When the highway patrol officer goes in and tells the nurse, I want a blood sample, that blood sample can be used as part of the criminal investigation. If it's taken as part of medical treatment, it ain't. And even though it's not testimonial for Fifth Amendment purposes, that blood sample taken at the direction of the doctor is medical treatment that is protected by physician-patient confidentiality, otherwise protected by Missouri statute. And the cops can't use it. So you want to request the employee to do it so that it's not necessarily medical treatment, and then that way you can use it as evidence in either a workers' compensation claim or discharge litigation if the employee sues you. Then the benefits are forfeited, the big zero, if one of two things are done by you. One, sufficient cause to suspect the use of alcohol, or your policy clearly authorizes post-injury testing. Now, how many of you are in companies where you trust your supervisors to be able to suspect the use of alcohol or illegal drugs? Let's see the hands. Not too many. A few. You should all train them. You really should. It's not that hard. So, if you don't trust your supervisors to figure what's going on, you better have a policy that clearly authorizes post-injury testing. Does the Zoom provide for that policy? Better look. What happens if no test is possible? There are still two more defenses that you can use. One is extremely rare. It comes up about once every career. And this is the case where the employee is so drunk or so drugged that they can't do anything. And there's one case in Missouri that stands for this proposition. It's called Haynes versus R.B. Rice. It came out of Kansas City. And it involved a fella who got his paycheck on Friday evening. He went out and he bought a weekend's worth of entertainment consisting of alcohol and cocaine that evening. And he had himself a party, but he was supposed to work the next day. He showed up the next day. Nobody saw him come in. He clocked in somehow. But the first time anybody saw him and the first time he remembered anything was whenever he was lying on the floor. This is food processing, R.B. Rice. It's the sausage company. And he was lying on the floor, and this hot water hose was beating scalding hot water on him, and he suffered third-degree burns. Big-time medical. I think it was 7-digit medical expenses even back then. In that case, it was ruled that he was so drugged and intoxicated that he could not have performed any work, even of incidental benefit to his employer. And benefits were denied because he suffered injuries that we call idiopathic, meaning personal to him. Meaning he got so drunk, so drugged, that he couldn't do anything at all. It wasn't that he did it negligently. It means that he was just lying on the floor, and there was no way that they could expect any work out of him. They just have to pick him up and haul him off. Now that is far different from doing the job negligently. Workers' compensation is a no-fault law. It applies regardless of negligence, yours or theirs. So this is a rare defense. There's a better example of what you need to be looking for if you don't have that, or if you have something wrong with your testing procedures, or if you really can't prove the level of intoxication. This is my case. I had a case where we had a delivery driver who delivered flowers from Joplin to Mountain Grove, Arkansas. And his route was being, this case is on the books, it's not private. His route was being cut back, meaning his revenue was going to be cut back, and he got mad. And he had, and I think it's Mountain Grove, Arkansas, it's on Highway 5 past the state line. And he was going to come back from there about the lunch hour, and rather than have lunch, he was mad and he was all stressed out. He decided he was going to have a Jack Daniel's lunch. And he had a pint in his big box truck, in the van portion of his big box truck, big box van about 27 foot long. And rather than take Highway 5 north and then take Highway 60 west to come back to Springfield, he was drinking, and he took all the little side roads south. And he took out 300 feet of fence on Highway 76 going west of here. And he had very significant burn injuries. My argument, I got the reduction before the division with the judge at the time, but I was very unsure whether or not the reduction would hold up. I had figured out, trying to work through all these issues, that he really wasn't in the scope and course of his employment, that he was on a personal lark, on a deviation from his employment. His injuries didn't arise out of and in the course of his employment, meaning because of and during his job, because he was just out drinking. He was going to go home anyway. All he had to do was drop off the truck at the terminal and go home. If he really wanted to get back and do anything else, he should not have been drinking, because he couldn't go into customers with that kind of smell on his breath. And the Labor Commission bought the argument. They said he was on a personal deviation from his employment. Well, that's not going to happen every day, but whenever you're looking at $100,000 in medical expenses, not counting his time off, which was about 6 months, not counting his permanent disability, which was about another $40,000, not counting his disfigurement, which was about another $15,000. Big claim. He got zero. So sometimes you just need to lay out the facts, put them on a timeline, and think about what you've got. And that normally comes with legal counsel, but it starts with you. One time I was working with an employer. This is really kind of an aside, but I think it's important because this shows what a good client can do to help your own case. Had a new client. They said, "Why don't you come by? We've got a problem employee and we don't know what to do with him." So I come to their office. They asked me back to this conference room, and the HR supervisor has 7 different reports of injury for on-the-job injuries in the past year for this fella. It has them laid out 1, 2, 3, 4, 5, etc. Client asked me, what do I do with him? In that situation, I looked at the information. I looked at the medical information behind all of them. There was a common thread of injuries. And I said, I think you have justification for an ADA medical examination. Now, Wooten over here is probably going to throttle me whenever I say something like that. But I really thought at that time that we had justification. Never heard another word about the exam. He underwent the exam. And guess what? After that exam, what was the incidence of his work-related injuries after that? Never had another one. Good employee. Turned out to be a good employee. I'm not sure how he was before. Things worked out. So sometimes you need to think things through. Use the timeline. Spread it out on the table and see what your facts really are. Okay, that's a cash register. What should you do? The whole point of this is to tell you what you should be doing. So that's why I put on the cash register. It doesn't sound like a cash register. Let's go complain to Bill Gates. But so whenever we're getting to action, you're going to hear the cash register. Remember, this is part of your program, like I said before. This is part of it, but it's not all of it. Do not have this program just to deny some benefits. Second, make sure your policy authorizes testing. Some of you may test random or post-incident or near-incident, post-accident, or post-injury. But say in the policy when you are authorized to test. I think that we have some public employers here. If you're a public employer, don't test random. Check with your lawyer to see when you can test, because there's going to be different rules for public employers, because whenever you're a public employer, you have different obligations that I won't go into here. So for public employers, you may not test random, but if you're private, you can start doing this as long as you have a policy that complies with federal law, and you can disqualify or forfeit benefits if you follow certain procedures. Make certain your supervisors are trained. There are testing facilities, quasi-law enforcement companies that can come in and help orient, train your supervisors to be looking for certain things. Odor of intoxicants, pupils, things that are clearly discernible. And there are forms and checklists that you can use, your supervisors can fill out, where they can talk about pupils, they can talk about breath, they can talk about stumbling around, they can check off this and check off that, check off this. And they do it at the time, and when it's prepared at or near the time of the observation, and if it's prepared in the regular course of the business, it's a business record. And if the supervisor goes halfway across the country for another job and is not around to testify at the hearing, if they have prepared that business record, it's admissible under the Uniform Business Records Act, 490, 680, and succeeding sections within the revised statute of Missouri legislation. You're good to go. So you at least have paper evidence, even if your supervisor's long gone. You with me there? So if you haven't trained your supervisors, think about it. And you know, forget the employee's workers' compensation claim. What is your obligation to promote safety for the coworkers and the members of the public that are around that employee? Isn't that the bigger picture here? Under the rules of negligence, shouldn't you be thinking about that? Document sufficient cause if you're going to go that way, and preserve it on a form. If you have a medical review officer, as I suspect you do, you need to check with them and make sure that the compliance procedures are being met. If you have questions concerning a mix, if you will, a cocktail of legal and illegal drugs, that's when your MRO is going to be very important. And then review collection for your analysis, hair, etc., samples, and testing. How many of you test for hair? Anybody here test with hair? We have one, at least one. I was at the Family Law Conference last year. They had it at Chateau-on-the-Lake. It's a statewide conference of lawyers who practice divorce and family law. In Kansas City and St. Louis, for whatever reason, they don't go through blood sampling or urinalysis anymore because of compliance and manners issues and all of that. They've gone to taking hair samples. Well, some of these people who are wise to the world shave. They shave here. I don't shave. I just lost it. But a lot of people shave. They shave here, they shave here, they shave here. There's one spot on your body where you wouldn't think to shave. And that's where your medical technicians take the hair samples. And that's as far as I'll go with that. But this is But this is going on. This is how sophisticated some of these people can be. Let's hope they don't move down to Branson. What else should you do? Here are the 6 W's, and actually there are some other questions that are interrelated with this. This is what the federal government will tell you that you need to be answering on every policy. And that's why I went ahead and put down these 6 W's. But you need to also clearly specify what is prohibited. You cannot do any work while you are under the influence. You cannot do any work if you have taken any illegal substances within the last 30 days. You cannot do any work if you have consumed any alcohol within the previous 8 hours. You must be that clear if you expect to get the reduction, and possibly if you expect to take any action. Okay. Let's talk about workers' compensation retaliation. Daniel is going to give you some wonderful news for you about changes to anti-discrimination laws in the state of Missouri and the effect that it's going to have on lawsuits. He's going to talk about caps on damages. He's going to tell you that you can't get sued anymore. He's going to give you all sorts of good news. And for discrimination on the basis of race, gender, national origin, all those things that you normally think of in either Title VII or Missouri Little Title VII law, this is all going to be good news for you. I am bad Platter, because I'm going to tell you about workers' compensation retaliation. Because when it comes to workers' compensation retaliation, since 2014, our law has been the code of the hills. This is what our law has been and will be until August concerning retaliation. This retaliation provision has been on the books since workers' compensation was enacted in Missouri in 1926. And it's pretty common. Almost any kind of employment law will have an anti-retaliation provision these days. And this at the time was very forward-thinking. And this is what it says and has said. No employer or agent shall discharge or in any way discriminate against any employee for exercising any of his rights under this chapter, meaning the workers' compensation law. Any employee who has been discharged or discriminated against shall have a civil action, lawsuit, for damages against his employer. So, that's pretty broad. It's not like Title VII actions or Missouri administrative actions where you get a complaint filed with the EEOC or the Missouri Commission and you go through this administrative process where you have about a year where you can get your ducks in a row. It's not like that. Fired today, gets sued tomorrow. This is the spectrum, and I'm going to come back to this one, because there needs to be a connection between exercising a right under the workers' compensation law and the discrimination or discharge. Until April 15th, 2014, the law was that the exercise of the workers' compensation right was the exclusive factor for firing the employee or otherwise doing something bad to them. So it was on the right hand of this continuum, way over here. So if they were a lousy employee anyway, and you could document it, if they were tardy all the time and you could document it, if they trashed the supervisor with 4-letter words every day and you could document it, all of those reasons were good enough to fire the employee, and you were protected because you could articulate, meaning say, a legitimate, non-discriminatory reason why they should be fired anyway. Lawsuit gone. Well, that changed. Law changed because of a Supreme Court case called Templemeyer versus W&M Welding. This one is a doozy. We have a welding company in northwest Missouri. Mr. Templemeyer is a painter and a laborer. A painter in a welding company is probably not your highest ranked employee. Well, Templemeyer has a big-time crush injury to one of his feet. He can't stay on his feet 8 hours a day, but thankfully, he's brought back to work under modified duty. One day, his owner says, his boss, the owner boss, says, Templemeyer, go paint that railing today, and I'll be back later. A supervisor says, Templemeyer, go do something else, and I'll check on you. Well, Templemeyer goes and does something else because that's the last instruction given him, I suppose, but he doesn't paint the railing. By the time owner comes back, Templemeyer's done with job number 1, and he's resting. Owner flies off the handle. This is kind of like Donald Trump's lawyer getting on email with that guy who was complaining about him. Blankety-blank this, blankety-blank this. You take my blankety-blank money and don't do your blankety-blank job. This is in the opinion. And one thing leads to another, and Templemeyer is fired for insubordination. His lawyer files a lawsuit, all with an eye towards reversing previous case law concerning exclusive factor. Okay? Case goes to trial. Case goes to trial. The judge instructs the jury it has to be the exclusive factor. Templemeyer loses. Templemeyer takes it on appeal, takes it through all the stages until it gets to the Missouri Supreme Court. And Templemeyer's lawyer says, judges, this exclusive factor requirement is wrong, has always been wrong, and you should reverse it and go back to the contributing factor. Missouri Supreme Court says, in a 5-2 decision, they say, you're right, and we are only going to require a connection of contributing in order to support a lawsuit. Meaning, even if you have a second reason to fire the guy or gal, as long as the discrimination was a contributing factor, a jury can still find you liable for discrimination damages, retaliation damages. And it was really interesting because the case came down 5-2 with the Missouri Supreme Court, and and all 7 of them said this exclusive factor was wrong to begin with. But 2 judges only dissented because, well, even though it's wrong, precedent means that we should not overturn it. And that didn't work. And contributing factor was important because before this year, before August 28th, contributing factor was your causal connection requirement for a discrimination action under Missouri law, such as discrimination on the basis of national origin, religion, gender, race, etc. And the Missouri Supreme Court said, we want to make sure all of this is compatible and consistent, so we're going to go back to contributing factor. Well, that changes in 6 weeks because we're going to take the middle ground. We are going to require a motivating factor. Here's the quotation for it. And this is consistent with what Daniel's going to talk to you about in Senate Bill 43. And this is consistent with federal law. So now, next month, you're only going to need to know one standard, and that's going to be this one. Now let's read it for a minute. For purposes of this section, motivating factor shall mean that the employee's exercise of his or her rights under this chapter actually played a role in the discharge or discrimination and had a determinative influence on the discharge or discrimination. A lot of words. What does it mean? Basically put yourself in a juror's shoes. If you get called for jury duty and you have a case to decide like this, was there a real connection between exercising your rights under the law with getting fired? If there's that, if a jury can remember that, and I suspect that most of them, that's what they're going to be able to remember, if they find that, then there's potentially a case of liability. If they think that the employee was such a horrific employee anyway, they're probably not. It's probably going to be a verdict for the employer. But that's really what you're getting down to. So from my standpoint, I don't care whether or not the definition is contributing or motivating. I'm looking more to the facts of that case. And if you have clearly documented here and here and here and here just how bad an employee is, and there happens to be a work-related injury right here, but the pattern of past employment practices and ongoing is such that their performance justifies termination, you're probably going to be okay. But there's no magic formula for this. There's no magic formula in this definition. So you kind of have to be like that good client that I was telling you about a few minutes ago. You want to keep your paper straight. And your paper, if you keep it straight, will probably give you the answers. Okay, what should you do? This lawsuit, like I said before, is not part of the Missouri Human Rights Act. You do not have caps on damages. There are actual damages. There are punitive damages. There are other caps on punitive damages under Missouri law, but sometimes they don't look much, for your purposes, like a cap. I consider there to be potential liability for employers and individuals. The statute may have a little bit of an ambiguity there, but I think that there's a potential for individual liability. You must consider work-related injured employees as a protected class, just like the protected class that you see under traditional employment law. And even though this is not a rule of law, this is a rule of thumb that I think you can use. There are what I consider hot spots in a workers' compensation claim in which you should use special care as to what employment action you are going to take with employees. That especially concerns reporting an injury, considering their ability to work, filing the claim, active medical treatment, and disability ratings. What do I mean by all of this? Would you fire an employee who reported a work-related injury the previous day? Doesn't look very good. Same thing with the ability to work. Do you really want to fire Templemeyer for insubordination when he had a medical restriction to stay off his feet? Do you really want to fire an employee the day after they file a workers' compensation claim? Do you really want to fire an employee when their active medical treatment takes a turn for the worse, such as a serious infection like a MRSA? Or are you going to fire the employee the day after they get their disability rating and offer for a settlement on their workers' compensation claim? Also, I've gotten these phone calls. I know that they've happened, and they may still be happening within the past year. But do you really want to have some sort of insurance company underwriting arm saying, you need to fire so-and-so and so-and-so and so-and-so because that'll help your loss run? I don't think so. My common advice for employers like you, whenever they get a question like that is okay, friend, are you going to indemnify us for damages when we get sued by this employee or this employee or this employee? Are you strong enough on your procedures? Are you confident enough with your procedures where you're going to indemnify us if we get sued? The answer is almost always no. And then I tell the employee to throw that brochure in the trash can. Okay, 12-month rule. This will concern some of you. It will concern all of your insurance companies that insure you, or if you are in what's called a group self-insured. And I don't want you, if you want to raise your hand, I don't want to have you identify yourself by employer or the group that insures you. Is there anybody here that's part of a self-insured group, like the Missouri Restaurant Association, Missouri Unified School Insurance Council, anything like that. Okay, so we're dealing basically with traditional insurance companies. Traditional insurance companies want to turn claims. Ideally, they like to turn claims within the policy year for you. So they want to get medical treatment started for a straightforward compensable accident. They want to get medical treatment started. They want to get all the treatment done. They want to see a rating. They want to see an offer. They want to see a division approval within a year. It's great in theory. Sometimes doesn't work. Medical treatment many times justifies a program longer than that, especially in the Springfield area where you basically have two medical institutions that offer integrated services. In Kansas City and St. Louis, this is not a big deal because you have lots of different hospitals. But in Springfield, you have two. Down here, you have two. And those are basically the same two as what you have in Springfield. So sometimes we have to line up. And sometimes you don't get the medical treatment done within a year. But usually, for most of your stuff, people are going to get out within a year. And that has all sorts of consequences. Insurance companies have bonus pools where they clear out reserves, all sorts of things. You have programs where you may even have personally incentives where you want to get claims off the loss run. And that means the division approves the settlement. There's no future possibility of ongoing medical treatment. It all gets done. Well, this is the reason for the 12-month rule. If a lot of employees, let's say we have a highway patrol trooper. Let's make it easy. Nobody here is, I think, is with MoDOT. But a lot of times you have a first responder like this, really good paying job, lifelong career. They suffer a serious knee injury, say. And let's say they have a kneecap fracture. And they have a disability rating. But they really don't want to settle because they don't know what the consequences, the long-term consequences are going to be of that kneecap fracture going forward. I've even heard judges and doctors tell people, wait until you go through a winter with your big-time bone fracture because you want to see if you're going to have arthritis. And that's something we can understand for all of us. Well, a lot of claims have sat. A lot of times people just want to see how they're going to do, and they don't want to lose their job. And they want to make sure that their job is solid before they settle. Sometimes they'll go to a lawyer, and the lawyer will set them up with a doctor, but that appointment is way down the road, maybe a year away. Sometimes they go to a lawyer, and the lawyer says, I can send you to it for a second opinion, but you're going to have to pay for it. So we have employees who literally make financial arrangements to pay for that second opinion. So they either make sure they have enough credit balance on their credit card, they sell their bass boat, they sell something else, they save money for a year, 18 months. And a lot of times this stuff takes time to work out. And I'll get to that whenever we talk about action plans. But at least now we are going to have supposedly a rule which says that if there's a rating and an offer, the employee is on the clock and has 12 months to get a second opinion. Here's what the statute says. In the case of compromise settlements offered after a claimant has reached maximum medical improvement, meaning after their condition has plateaued, upon receipt of a permanent disability rating from the employer's physician, a claimant shall have a period of 12 months from such date to acquire a rating from a second physician of his or her own choosing. Okay, sounds straightforward. Well, that's great, but what happens if they don't? Slide number 2. Absent a finding of extenuating circumstances by an administrative law judge or the Labor Commission, which is in Jeff City. If after 12 months a claimant has not acquired a rating from a second physician, any compromise settlement entered into under this section shall be based upon the initial rating. Okay? That sounds simple enough for real people like you, but for lawyers like me and for judges, there are problems. What if the employee and his attorney say, well, we'll just try the case? This statute is not binding because it only applies to compromise settlements. What if, and I'm not sure what the answer is going to be here, but what if you have a rating from the treating physician and the second opinion doctor says, treatment is not over, you should be doing X, Y, and Z in a treatment program because they're not at MMI yet? Well, I would expect that to be an extenuating circumstance that relieves the employee of the obligation to have a second opinion on permanent disability. Some doctors are now already saying, well, they haven't had all of their medical treatment. Their disability is 50%. Once they get treated, I would expect it to be down to 30%. That rating is going to comply with that statute, I'm sure. I was over in southeast Missouri 2 months ago, and I was listening to a bunch of lawyers over there. And they're pretty rough over there. If you do business over there, you've got a tough crowd to deal with. And they have about 10 different reasons why this statute doesn't really mean a big deal. Sure, all of us want to settle cases quicker. Believe it or not, employees many times want to settle cases quicker. And it's a matter of everybody getting together and figuring out what a reasonable settlement is. Because you're going to have your rating, the employee is going to have his or her own rating, and something has got to happen in the middle. And you're going to feel very strongly that you have confidence in your own doctor who you have designated and authorized as the treating physician. On the other side, I hear the stories every day, and the judges hear them too, where Dr. So-and-so didn't look at this, Dr. So-and-so wasn't listening to me, Dr. So-and-so did not examine me, he just talked to me. Hear that all the time. And then they go out and they get a second opinion, many times with their own money, and at that point, folks, I guarantee you that that employee is very much invested, pun intended, in that case. Because if you have an employee that has put his or her own money to paying for that second opinion, they're going to want to get every dime out of it, and that makes settlement tougher. And a lot of forward-thinking TPAs, insurance companies, claims reps will have a dialogue with their defense counsel where we think, okay, well, this rating from our treating physician is here. We normally see a range of disability ratings in this range here. This is the top end of reasonable. This is the bottom end of reasonable. Why don't we cut through all of this and offer something here? Now that works well in theory, and many times it works well in practice. The times that it doesn't work is whenever we have an auditor, and I put that in air quotes, whenever we have an auditor who comes back and second guesses what the settlement value is for. Beware of audits by TPAs who are not currently conducting your business. I would respectfully suggest, and I'm not going to diss everybody here, but be on the lookout for TPAs who are doing these audits as a marketing reason rather than really looking at what is being paid properly and not. That's very important, because if somebody is just coming in and second guessing, that doesn't do any good. And sometimes these second guessers work within the company that insures you already. And there's all sorts of little political machinations going on why maybe we shouldn't have paid that much. Well, they didn't work on the case. So this is a big deal. There are many consequences from this rule. Number one, and the most conservative judge in Southwest Missouri told me this, words right out of the mouth. That judge said, this is going to promote more lawyer advertising. You're going to hear it come August all the time. You can't trust the insurance company, and you only have 1 year to get your own doctor's rating. We're going to hear that ad nonstop. So if you want to avoid attorney involvement, which is one way of putting it, you'd better have a dialogue going on with your employee, whether it's the claims rep, whether or not it's you, whether or not it's both of you, whether or not it includes me. And a lot of times I'll come and speak with these folks, and I'll come dressed much like I am today, although I'll take my jacket off because I don't want to scare them off with a necktie and a three-piece suit or two-piece suit or a two-piece suit and suspenders. But the point is that you've got to have a dialogue with these people if you want to be able to close these cases within 12 months or within your target time, whatever that might be. This will give claimants' attorneys more reasons to get what I call comprehensive examinations, in which they don't just get a rating, which is normally cheaper, but they'll get an assessment on the length of time off, the necessity of future medical treatment, the employability of that claimant to go back to work in the open labor market. Because lots of times you'll get reports and the rating is bing and that's it, and everybody settles it. Some cases you get reports that are 20, 30 pages long, and it goes through all of the medical history, and you get an assessment of different opinions that will range in and of itself like 5 to 10 pages, and you have to go through all of that. And because you need to be able to find out what dollars are at risk so the insurance company or TPA can set reserves for you. This may speed up some cases, but I anticipate that it will intensify the work necessary to get the job done. Meaning, some lawyer like me is going to call you on the phone and say, okay, how's John doing with his job? Is he working full duty? Is he having problems? Sure, he doesn't have any official work restrictions. However, is he having trouble doing his job? Is he getting help from his friends? And if you can't tell me, who can? It's probably that supervisor that doesn't know who doesn't know what a drunk employee looks like. But I'm going to want to talk to somebody to get the bottom line on what somebody can do from a physical standpoint on their job, so I know what I can recommend as a settlement on your behalf. And the last one, and this is important, and I know this deep in my bones, there are lawyers, and then there are lawyers. There are some lawyers, they just want to get a case settled, they want the client to be happy, and they're not going to worry about all the details as long as there is closure within a reasonable period of time. Some lawyers are cleaners. And they're cleaners because they know what they're doing, and the employees that come to them are the ones that got mad over the medical treatment. They got mad over being fired. They got mad about being dissed and talked about at work. They could be mad for any number of reasons. And those employees come to cleaners and they say, I want every bit of what I'm entitled to. And those lawyers count the beans. They count every single one, and they expect every one of them paid. Those lawyers are going to make a mint off this rule. That's my prediction. Okay, what should you do? This is the reverse cash register. This is when money is going out of your pocket. But in order to minimize the amount of money going out of your pocket, think about these things. Use this time when medical treatment's over, when the offer's being made, to address the rating and an effective return to work. You want to coordinate with your claims representative who's going to be talking to the employee about certain subjects. Most of the time, the claims representatives will be responsible for explaining the benefits. Very important. The claims representatives need to be available on the phone to talk about the disability benefits and to explain how they are arrived at. If they can't get the claims rep on the phone, and I know that everybody's busy, this lawyer and every other lawyer knows just how hard it is to stay on top of phone calls. But if they can't get a hold of that person, there should be backup people they should talk to. And what I typically do is that I will give the injured employees the phone number and name of the claims rep, of myself, and of, hopefully, if you want to, an employer's contact where they can get somebody on the phone before they call 1-800-333-3333. Are you with me? So you want them to stay engaged with somebody where somebody will get back with them. I'm not saying that all of these people need to be enabled to think that they can have a return call within the same day. A lot of time it's going to be the next day. If I'm on the road like I am this morning, there's somebody at the office that takes messages so that I can return them while I'm driving back to Springfield or on Monday. But it's not like we're leaving people dangling. You need to engage them. Expect a final assessment from the physicians to assess the job description that you have for that employee and all of that job description. Do not accept or necessarily be satisfied with the work restriction of no lifting over 50 pounds. As I'm going to show you in a future slide, that doesn't address the employee's job. Now, that might be the only restriction that the physician believes is appropriate, and he thinks that they're able-bodied otherwise, but they should say that. And some of the best doctors around, they get in a hurry and they say, no lifting 50 pounds, no lifting 25 pounds, etc., etc. That does not work. You need a full assessment because I guarantee you a lot of the employees who are coming back to work are going to have all sorts of problems that they want to address. We hear those problems at the initial conferences with employees before the administrative law judge, and yours truly gets embarrassed because the employee has this list of things to complain about, and the restriction looks like this. And I have to go back to the doctor 4-6 months after that rating and say, Doc, remember so-and-so that you saw 4 months ago, 6 months ago, and you said this? They're complaining about this. Would you assess that? Oh, I'd love to, but I need to see them again. Okay, well, see, that's another 2 months. That's another reason you're not closing your books on time. And if timing of claims is important, if you executives and owners really want cases closed, make sure that your staff tickles the cases for review. 60 days, 120 days, 90 days, whatever, but make that uniform. The Outlook calendar system is wonderful for that. Okay, let's talk about Subchapter S shareholders for just a moment, and it probably won't address your job that you're on here today, but it may very well be important in the side job that you have, and it will be very important with the vendors that you hire. Coverage is not going to be required for owners of businesses under certain situations. We already have a situation where if you're the employer, like if you're the partner in the partnership, you can file an election not to be covered under the law, meaning, for 2 reasons. Number one, your pay goes off the books for the payroll audit. And number 2, that takes away 1 employee under the requirement that 5 employees need to be there for purposes of having insurance coverage. Very important. If you're a Subchapter S, and if you own 40% of the interest of the Subchapter S corporation, starting in August, you can file an election with yourself, the corporation, and your insurance company that says, take me off the rolls, I will no longer personally get workers' compensation benefits. Meaning, I am strictly an employer. I am not an employer and an employee. Okay? Officers of corporations are normally, under the general rule, employees of the corporation. Members of LLCs, members of LLPs like Wooten and me, we are officially employees of the LLC, or in our case, our law firm partnership. So if you file the election with the insurance company, it works from that date forward that you're no longer covered. And what that means is that your premium's going to go down. And number two, that's one employee that you knock off in what I call your count towards 5. If you have 5 employees, either traditional employees or workers regularly working on your behalf, you have to have coverage. But if you, going off the rolls, knocks you down below 5, and if we are confident of that conclusion, then you don't need a policy. Now, you might want a policy anyway. I would suggest that you have a policy because if your payroll goes down a lot, your premium's going to go down a lot too. And Connell's going to throw me out of the room for saying this, but, you know, for small businesses, this is a big deal. There have been home builder companies, and that's probably a bad example. If they have one employee, they've got to have coverage. But there are small businesses in competitive industries where a workers' compensation premium is a big factor towards being competitive or not. And a lot of small businesses will go bare and risk it, and they'll get bids and they'll get work where the guy who follows the rules loses out. So this is one reason why I want to point this out. Next, compare this with LLCs. If Wooten and I say, these workers' compensation premiums are just killing us, we need to file an election to go off the rolls. We can do that, but we have to file it on a specific form issued by the Department of Insurance, and such a form exists. I saw this form yesterday. It's still good. This requirement for LLCs and LLPs, you still have to use the form, you still have to turn it into the division, you still have to give it to the insurance company. For your subchapter S's, and you can see this in the Senate Bill 66, it's 287.037 subsection 1 for LLCs. You have to send it into the state on its form. For subchapter S corporations, you send in a notice, and that's all. Okay, what should you do in connection with this subject? The biggest thing that you need to be thinking about is probably, besides your side businesses, and I suspect some of you do have those, but in terms of your main job that you're here because of today, if one of these owners goes off the rolls, as I call it, then they are no longer covered as an employee under workers' compensation, but then they probably have a lawsuit. We have and that is a lawsuit for injuries caused by a negligent failure to provide a safe workplace. This can happen with a lot of maintenance companies. A lot of maintenance companies, their workers are arguably counted as statutory employers of places like this, of educational institutions, of office buildings, where you have basically a maintenance crew there all the time, and you don't want to have them on the books as your employees for various reasons, but they establish a separate business and you pay them a fee for the year, and then they pay everything out of that, and that makes for a lot less paperwork for you. Well, that's fine, but if the owner of that maintenance crew happens to be considered an employee or agent of yours, and you have left something on the premises that injures him, he has a direct action lawsuit against you for injuries he suffers or for his death. And normally I consider what I call open air claims, not a claim for us office employees, but for but for workers who work outside, those are normally more high-risk, high-injury claims than otherwise. So whenever you make sure that you get the binder to show that that maintenance company has workers' compensation coverage, get a verification that the owner is covered too. Because if the owner is covered under that policy, the owner cannot sue you. If the owner has elected out like this, the employer can sue anybody he wants for injuries he suffers. And we have a lot of small businesses like maintenance companies, and there's a bunch of other examples where the guys and gals who own these businesses, they will work right alongside the employees they supervise, and they are just as prone to either getting hurt or hurting someone else. And you want to make sure that if the workers are covered, you want to make sure that owner's covered too. Okay, let's talk about MMI for a few moments. Maximum medical improvement has been a concept we have always had. You will hear about MMI all the time if you're in the business very long. What I'm going to tell you means that the law really hasn't changed. This has come up because of a case called Greer versus Cisco, where the Missouri Supreme Court decided this one as well in 2015. Mr. Greer is a warehouse employee for the big Cisco food company, and he suffers a crush injury to his foot because our genius, Dr. Einstein, Mr. Greer, left his foot outside the forklift that was going down a path, and it was crushed by a forklift coming the other way. Not too smart. Well, it's a crush injury. He has initial surgery to close his fracture. He's on physical therapy for several months. He has returned to work. But he continues to suffer complaints, mostly neurological. He has pain, tingling, and numbness in his foot. He goes to various physicians. He quits his job. He goes to various physicians, and none of them can find out what to do with him. He finally gets to another physician. Think about the 12-month rule when you think about Mr. Greer's case. He finally, after like 3 years, finds an orthopedic surgeon and a plastic surgeon who say, you have tarsal tunnel syndrome in your foot. Tarsal tunnel syndrome is kind of like carpal tunnel syndrome, but it's not in your wrist, it's in your foot. And we'll take care of that tarsal tunnel syndrome. It'll be what's called a release and repair. We resect the nerve, meaning we cut out the damaged part, we sew the nerve back together, and we make sure that it's a free nerve that's not impinging on bones and such, and tendons, and your foot's going to get better. Well, it got some better. Well, we go to a hearing, and Mr. Greer wants temporary disability benefits for the time that he was post-op on his foot. Way down the line, way after he had been rated. Well, these cases happen every so often. Sometimes we get lucky, and we're just talking about the period of time for post-op following the surgery. And that's normally like 6 weeks, 8 weeks, a few months. That's not bad. Sometimes the employee wants temporary total going back to the date of the rating. And in this case, it was years. Those are nasty cases. Sometimes those cases happen, and sometimes those employees get what we call back comp, dating back all back to the date of the rating. Well, the division judge didn't give the temporary total because the rating had been established. The Labor Commission had none of that. They said, hold it. He was not at maximum medical improvement because he had tarsal tunnel syndrome, and he needed surgery, and that laid him up for however long it was. The opinion doesn't say. So we're going to give him benefits. The Missouri Supreme Court says, yeah, that's right. He gets his benefits for 2 reasons. Number one, he was not at MMI. The Labor Commission had what we call in the law substantial evidence to believe he was not at maximum medical improvement. But number two, and this was the dangerous part, some lawyer out of St. Louis for the employer stipulated that the vocational rehabilitation statutes applied to this guy. And that statute says temporary total shall be paid during the quote-unquote rehabilitative process. Awful. Awful. Voc Rehab in Missouri is voluntary. There was no evidence that Cisco ever provided Voc Rehab services for this guy. Nobody uses Voc Rehab in Missouri, period, because it's voluntary, because it's expensive, and because nobody wants to try and beat a permanent total claim by sending them through a program. But the council agreed that this statute applied, and the Supreme Court said, well, if you're going to stipulate that this statute applies, this is another reason to pay the benefit. And they finally, after 2.5 years, got enough sense to cut this nonsense out because we don't use Voc Rehab. So this is the definition of MMI that is effective August 28th. That's the official date. But unofficially and in real truth, we have always used this definition. So the first reason to give Mr. Greer his benefits did apply, it would always apply, and it will apply in the future. But whenever you have tarsal tunnel syndrome, a pretty significant neurological condition in your foot, and when the previous doctors didn't diagnose it or treat it, and 2 surgeons operated on it, don't you think that that was a condition that could reasonably improve with additional medical care as determined with a reasonable degree of medical certainty? Yeah. So if you bring this case to me, I'm going to tell you, well, that's nice that there's a definition of MMI, but if we have good doctors saying, I can fix that, there's going to be temporary disability benefits owed, notwithstanding the first rating. Okay, cash register. It's the reverse cash register again. Please, if at all possible, offer modified duty, especially during medical treatment. Again, and double please, if possible, offer it at MMI, but remember that you might need to talk to Wooten or me about ADA implications. Also, for lengthy medical treatment in which it is reasonably foreseeable, and I'm not using the words of the ADA legislation here very well, but if it's reasonably likely that you have and will have a chronic condition, ADA may well be implicated and triggered before you ever get to an MMI date. So you got to watch that. And then finally, consider all of the final restrictions and compare it with the full job description. Full job description. Pull it off your directory and look at it and compare it with what the guy or gal can do. And sit them down and say, can you do this job? And get a form, I have them, and go through their job description with them and say, can you do this? Can you do this? Can you do this? And you say, where do we stand? Because if you don't do that, and you say, well, you know, you have a restriction that closes you off from employment, we're not going to make a reasonable accommodation under ADA, and you fire them, you know what they do? They file for permanent total disability benefits. And I can't tell you how many phone calls I've gotten where I'm not contacted until we have a rating, where there is a restriction that supposedly DQs an employee from a particular job, and they're getting ready to be fired. Well, those folks don't want they don't want a retaliation action. They want a PTD claim for permanent total disability, where they end up getting paid $300 a week, $600 a week, whatever their compensation rate is, for the remainder of their lifetime. Think through the gritty details. This might be the most important slide you get. Every job description should be thinking, and work restriction sheet should be looking through that column on the left-hand side, and the examples or specifics that correlate to those categories. It's a real important slide. You want to think through their job and see what they can really do, and if there's other stuff that they could do that would be appropriate for your job site, within ADA, of course. Please don't fire them. Continue to employ them. Line of duty compensation, I've just put it in here to let you know that for air ambulance people, firefighters, police officers, there's an extra $25,000 benefit for those people that are killed in the line of duty. We had this as what I would call a pilot program for 5 years. We have extended it until, what's the year? 2025. It's basically $25,000. There's ways of distributing the income, or the benefit. I think it's worked out pretty well. I've had very few cases with this. This is just part of the claim. This is paid for by the state. You don't pay for it. But if you're a hospital, if you're a public employer with first responders, this is a little extra something that can be important for folks. And frankly, for any of you who are middle-aged, who have had family members who have passed away, you know from first experience that there's a lot of stuff to get done. There's a week, 2 weeks, where you just need to sit down and figure out where Auntie Ethel kept this and kept that, and you need to get the house cleaned out. You need to give stuff away to family members if you can, and if that doesn't work, you may need to open up an estate. But the legislation that's in Senate Bill 66 pretty well sets forth what you're going to need to be able to do. Unfortunately, this act is a little hard to read. It's 287, 243, but if you punch through it, you can understand it. This is just a summary here, but it can be important. And $25,000 extra for a family in this sort of situation, it is an important benefit. Okay, there's a reason I look the way I do, that I don't always wear a necktie on Fridays, and that's because I love to eat, and I love onion rings. And the best part of the onion ring basket is it's the little crunchies at the bottom. These topics are the little crunchies at the bottom. We define in Missouri what voluntary separation is now. This is the same thing that we've always had. If an employee quits on you, you don't owe them temporary total or temporary partial. What we have practiced for a generation is now in the written statute. So if they quit voluntarily, you're done with paying them comp until MMI. If they can't work due to the fact that you force them to work past restrictions, there's going to be an issue between you and them as to whether or not the separation is voluntary. But if they voluntarily quit to go off and live with a girlfriend in New York, you're in the clear. Death benefits. We've never paid them to stepchildren before, but now we can if they're claimed as dependents on tax returns. And if you're in self-insured trusts, I didn't see any hands, so I'm not going to worry about that. But there are ways for groups to force new applicants to pay premium up front and then to invest surplus money that's carried over from year to year. Everybody have a great weekend. This is a great conference. Thank you very much.
Thank you very much, Pat.